Hello and welcome to Legal Thinking from Royds with you King. I'm Liam Pape and as always I'm joined by my esteemed co-host Ed Wotton.
Oh, very nice of you to say, Liam. Very nice of you indeed. This week we are talking about the commercial rent brackets, coronavirus end brackets bill, which is expected to come into effect on the 25th of March 2022, which probably by the time we post this will be tomorrow. The bill will be introducing a binding arbitration process to settle certain commercial rent debts. So what we've done this week is invite on Paula Green and Ian McEwan from our property disputes team to just basically talk about all the different issues it might arise from it and, you know, what the process is.
And just before we play the interview, there will be a special prize for anyone who can guess how many times we say the word arbitration during this interview. And the person who guesses to the closest 100 or the closest 1,000? Probably who guesses to the closest 1,000 wins.
Yeah, I think that's probably going to be more accurate.
There's a lot of arbitration to talk about. Let's roll the tape.
Okay, so thanks for joining us, Paula and Ian. And our first question about the bill will be to Paula, which is, you know, why is the government introducing the bill in the first place?
Thanks, Ed. During the early stages of the pandemic and in an effort to help protect business tenants who were struggling to pay their rent, the government introduced various restrictions on the enforcement action that can be taken by landlords in relation to commercial rent arrears. And those restrictions prevented landlords forfeiting for non-payment of rent, using the commercial rent recovery arrears process, or from presenting a winding up petition against tenants. Now, those restrictions are due to expire at the end of March this year, and tenants are now in a situation where, you know, they're trying to continue to operate with these rent debts hanging over their heads. The Treasury, for example, has estimated that there's probably in the region of about £9 billion worth of these rent arrears. So it is a significant problem. And as part of the government's commitment to try and assist and alleviate this problem, they've introduced the commercial rent coronavirus bill. Now, the aim of the bill is to help landlords and tenants resolve these rent disputes through an arbitration scheme, which comes into play exactly when the restrictions are lifted. And we anticipate that those restrictions will be lifted, as I say, 25th of March. And the scheme will allow the appointed arbitrator to determine what relief, if any, should be awarded to tenant in respect of these substantial rent debts.
So you mentioned there certain rent debts. And what rent debts are covered by the bill, Paula?
The bill applies to protected rent debts, which arise in respect of a business tenancy which is adversely affected by coronavirus. So if we break that down, first there has to be a protected rent debt, which is a debt relating to rent, service charge, insurance rent, interest, and VAT. Next, that protected rent debt has to arise in respect of a business tenancy, and that business tenancy will be treated as having been adversely affected by coronavirus if the whole or part of the business carried on at those premises was required to close due to coronavirus. And finally, that protected rent debt has to have accrued during a ring-fenced period called the protected period. Now, that ring-fenced period is a period of occupation between 21st of March 2020, and that's the date when the first requirements on businesses to close their premises or cease trading under the coronavirus regulations kicked in, to the date when the restrictions were removed from the market sector relevant to the tenant. And you know the relevant dates because there's a new code of practice issued by the government, and it helpfully sets out a whole list of dates where the market sectors are required to close. So that's a good reference point.
Yeah, so on the code of practice, Ian, can you tell us a bit more about what the code of practice is, how landlords have been, and tenants, I suppose, have been complying with the recommendations as well?
Yes, no problem at all. The code is it's a voluntary code, first of all, but it's essentially guidance from the government on how they expect landlords and tenants to negotiate in relation to these rent debts that have accrued during periods of forced closure. And it sets out guidance and recommendations, specifically encouraging collaboration and transparency between landlord and tenant, to try to get them in a position where they can agree between themselves an affordable rental agreement, one that's essentially acceptable to both parties and that will allow viable businesses to survive, having been severely hit during the pandemic. And it also, as Paula said, sets out details of the arbitration scheme that hadn't previously been forthcoming from the government. So that's the main crux of the code. And in terms of whether landlords and tenants have been complying with the recommendations in it, I would say that largely they have. I'd say the majority of landlords and tenants that we act for and come into contact with have embraced it to a certain extent, not all, but although there are around £9 billion worth of arrears outstanding relating to this period, as Paul has already said, we have found that the majority of our clients have come to some form of arrangement with their landlord or their tenant, which has allowed them both to get on with their lives, carry on their business, and maintain the relationship. So I'd say the engagement's been quite good.
So just on the arbitration point, if a landlord and a tenant have not been able to settle their protected rent debt dispute, how would they go about starting the arbitration scheme? Paula, do you want to pick this one?
Yes, please. Either the landlord or tenant can refer the matter to the arbitration scheme, and they have to do so within 6 months of the bill coming into effect. So that would be 6 months, we think, from 25th of March. Now, the government's issued a working draft of the statutory guidance which the arbitrators have to use when they're exercising their functions under the bill. That statutory guidance, the draft, sets out 3 stages of the arbitration process. The first stage is the pre-arbitration stage, where the arbitrator doesn't get involved, but the parties sort of take the initial steps in relation to the referral to the arbitration. So first of all, there's a letter of notification. So one of the parties has to say that I'm referring this matter to the arbitration scheme. Along with that letter, that party would have to submit a formal proposal for resolving the dispute. Within 14 days after that, the respondent, the other side, will either accept the proposal or make their own counter proposal and put forward their supporting evidence. If the respondent submits a response, the reference to arbitration can then be made 14 days after that. If the respondent doesn't reply, then the reference to the arbitration can be made 28 days after that. Then each party has an opportunity to put forward further proposals and with supporting evidence. We then have stage 2, where the arbitrator assesses whether the dispute is eligible for the arbitration scheme. So the arbitrator will go through whether the criteria has been met under the bill. And the final stage is stage 3, where the arbitrator's assessment of the matter of relief for payment of the protected rent debt is sort of gone through that process. And the arbitrator will consider the tenant's viability and the landlord's solvency and determine what relief, if any, is going to be applied.
Yeah, and that's what I was going to ask next. Is how is it that the arbitrator actually assesses the tenant's viability and the landlord's solvency?
Yes, I mean it does seem quite a process, and the bill has set out the sort of 2 fundamental principles that the arbitrator has to apply. The first principle is that the award made by the arbitrator should be aimed at preserving the tenant's business if it's viable, or restoring and preserving the tenant's business if it's not currently viable, but it would be if the arbitrator gave relief. The arbitrator also, in carrying out that exercise, has to consider preserving the landlord's solvency. So when the arbitrator comes to assessing whether the tenant's business is viable, the arbitrator should consider the tenant's assets and liabilities, previous rent payments made, and the impact of coronavirus on the tenant's business. And conversely, when the arbitrator is assessing the landlord's solvency, the arbitrator has to consider the landlord's assets and liabilities and any other information regarding the landlord's financial position. So that's the first principle. The arbitrator then has to consider the second principle, and that relates to whether the tenant should pay its rent debt in full and without delay. Now, the arbitrator must consider the proposals put forward by both parties and must make the award set out in the proposal that is more consistent with those two principles I've just referred to. It's only when neither party's principle is consistent. It is only when neither party's proposal is consistent with the two principles that the arbitrator then has a discretion to make their own award by applying the two principles. So the idea is to make sure you put forward a very well-reasoned proposal that is in line with the principles that the arbitrator has to apply.
And I'm right in thinking that arbitration is going to be quite an unpopular option for both tenants and landlords, because my understanding is that it's extremely transparent. So businesses, or tenants rather, want their financial information and ultimately their business viability being made public. Is that right?
Well, there will be, I can imagine, some documents that will need to be disclosed in order to assess viability and solvency, those documents not being in the public domain. So, that obviously is a concern for some parties. But when the arbitrator comes to publish their award and the reasons they've made it, confidential information, information to protect, the legitimate business interests of the parties, that needs to be redacted if the parties haven't consented. So I suppose you've got that sort of safeguard in place.
Okay. And what powers does the arbitrator have, and what awards can the arbitrator make if they find either particular way?
Yeah, so I mean, looking at the principles that the arbitrator has to apply, I think the arbitrator has to make sort of a just commercial assessment about the maximum amount a tenant can pay and a maximum amount a landlord can write off, with both parties remaining viable and solvent. So the arbitrator's award can write off all or part of the arrears, can spread payments, or can delay repayment of arrears by up to 2 years from the date of the arbitrator's decision. So that's, quite wide-ranging, really.
And Ian, just coming back over to you, how long will the arbitration scheme be open for, and who will the arbitrators be?
The arbitration scheme will be open for referral for a window of 6 months, beginning on the 25th of March. So the window will open on the 25th of March, and as things stand, it will be open to either landlord or tenant to refer the matter to arbitration for 6 months. But there is a provision allowing the government to extend that window if it's deemed necessary. And given how things have progressed throughout this pandemic, one can imagine how that might well be exercised. But the 6-month period starts on the 25th of March. And in terms of who the arbitrators will be, they will be government-approved bodies, and they will be approved by the Department of Business, Energy and Industrial Strategy in line with an acceptance model, which forces them to show various competencies to carry out arbitrations of this type. Once approved, those bodies will then have to list their individual arbitrators online and in publications, and then landlords and tenants who wish to refer to the scheme can do so direct. They won't have to go through the government. They can just go to an approved body.
Okay, great. And with any sort of process like this, there's going to be costs incurred for tenants and kind of landlords alike, I'm sure. So kind of an open question to both of you. What what about cost recovery? How is that factored in? Is it factored in?
Yeah, sure. I'll take that one. Unfortunately, it's not. Unlike in litigation where the winning party could expect to recover a good proportion of its costs incurred, there's no such corresponding provision or power within the legislation to allow the arbitrator to order that one party pay the other's costs. So parties are going to be looking at paying their own costs up front of this exercise and not recovering those costs from the other party. I think realistically, there's provision in there that allows the arbitrator to order that the party who didn't refer the matter to referral has to pay one half of the arbitrator's fee, but it's going to be the party that makes the referral that pays the arbitrator's fee up front. That's the only cost provision in there.
As well as introducing the arbitration scheme, the bill also introduces a ban or moratorium on landlords taking enforcement action. So what is this new moratorium and what are the restrictions that are imposed during the moratorium period? Ian.
Yeah, thanks, Liam. The new moratorium period is going to be a period that protects tenants from landlords taking enforcement action in relation to protected rent debts only. And as Paula said earlier, protected rent debts are those that fell due during the periods of forced enclosure, and that there's more details set out in and annexed to the code, setting out for each individual sector what periods they relate to. But this moratorium period will run. It will run for two separate periods. One for disputes that are referred to arbitration, and one that aren't. So in the case of a dispute between landlord and tenant that isn't referred to arbitration, this moratorium period will simply be 6 months from the 25th of March, again, unless it's extended. However, in the case of a landlord or tenant who does refer the dispute to arbitration, the moratorium period will run from the coming into force of the legislation on the 25th of March until the arbitration is finally resolved. So in the latter case where a dispute is referred to arbitration, you can see that the moratorium period can be considerably extended. And in relation to the restrictions that were imposed during the moratorium, these relate again purely to protected rent debts, and they're quite wide-ranging and really mirror much of what landlords haven't been able to do during the current period up to the 25th of March of this year. But from the coming into force of the new moratorium period, and I emphasise again it's in relation to protected rent debts only, landlords won't be able to start a new debt claim to enforce the claim for those arrears. They also won't be able to use the commercial rent arrears recovery regime to recover sums in relation to protected rent debts. They won't be able to forfeit commercial leases for non-payment of these protected rent debts. They also won't be able to draw upon rent deposits. And in circumstances where they have drawn upon a rent deposit prior to the coming into force of the legislation, they won't then after it be able to force a tenant to top that rent deposit up. In addition, there's a couple of insolvency restrictions that will be placed on landlords during this moratorium period, and in particular, they won't be able to present a winding up petition against a company for a protected rent debt, save where there is sums due and owing to that landlord that aren't protected rent debts. And in relation to individuals, finally, where you have an individual tenant rather than a corporate tenant, a landlord will not be able to issue a bankruptcy petition at all against an individual tenant during that period in relation to a protected rent debt. So the restrictions are quite wide-ranging for this moratorium period, as you can probably tell from what I've just said.
Yeah, definitely. But there might well be rent arrears that aren't protected by the bill. What happens with those? So
in relation to non-protected rent debts, i.e. those that have accrued but which fall outside of the protected period, there are certain measures in place up until the 25th of March. But they're due to fall away. And so in relation to non-protected rent debt, so for those arrears after the 25th of March, it will be essentially as we were prior to the pandemic restrictions coming into force. And that means that landlords will be able to issue debt claims at court for arrears of non-protected rent debt. They'll be able to forfeit commercial leases under the forfeiture provisions. They'll be able to use the commercial rent arrears recovery regime. They'll be able to draw down on rent deposits, and they'll also be able to require tenants to top them up. They'll be able to pursue individual tenants via a service of a statutory demand and then issue of a bankruptcy petition, which they've been able to do in any event. And after the 31st of March, they'll also be able to pursue corporate tenants via service of a statutory demand, followed by the issue of a winding up petition.
And we kind of touched upon this earlier, but back to you, Paula. What do you think the likely uptake of the arbitration scheme will be?
I think it's difficult to say, Liam, at the moment. The government's impact assessment estimated that there were approximately 15,000 businesses that are going to be eligible for this arbitration scheme. They estimated that about 7.5 of those businesses would go through the arbitration. Now, I can't say whether those figures are anywhere near accurate, but I think if there is going to be a big uptake on the arbitration scheme, then this 6-month window to start the arbitration process may well be extended by the Secretary of State to let all the arbitrations go through, because it is going to be quite a big backlog, and I don't know how many arbitrators are going to be available. So a bit of uncertainty on all that at present, I think.
Yeah, I can imagine. And final question, what are the other options available to landlords at the moment, and what are we advising our clients? And this is one for both of you.
Now we're right up against the legislation coming into force, that there aren't really many other options available. I think realistically, if a referral to the arbitration scheme isn't about to be made, you continue to negotiate between yourselves to try to avoid the upfront costs of that or litigation in the longer term. It seems to me that negotiation is the obvious option here. And in terms of the second question, what are we advising our clients to do? Negotiate is right at the top of the list, isn't it, Paula, at the moment?
Absolutely, because if you can reach an agreement, you've got certainty, and you can avoid the costs of the arbitration. So absolutely, both Ian and I are advising that, negotiate in accordance with the code. But if a party is going to go through the arbitration process, then, as I mentioned previously, the formal proposals that are put forward, that's a very important stage in that arbitration process. So landlords and tenants will be well advised to seek advice from the professional advisors on that, because those detailed proposals have to correspond with the principles that the arbitrator has to consider. So, for example, tenants will want to start collecting financial documentation to show that their businesses are viable, and if they're not viable, then they have to put forward proposals to show that they can be with relief. And conversely, landlords will need to collect evidence of their solvency, either on a cash flow or balance sheet basis. So again, sort of professional advice is needed on both those fronts.
Yes, it's a good point, Paula. When we consider that the window for reference is only open for 6 months, and collating all of this information is going to take, in best case scenario, imagine several weeks, and then you have to go through the formal process of putting forward your proposals prior to making the reference, you can see that the window will actually be significantly less than 6 months if you're only just starting the exercise now. So yeah, along with encouraging negotiation, we're also encouraging our clients to ramp up their efforts in putting together the information that they'll need should they wish to refer to arbitration.
Well, thank you very much both. That's very detailed coverage of what people can expect from the bill. So I'll just say thanks very much for joining us.
Thank you, Ed. Thank you, Liam.
Yeah, pleasure. Many thanks.
Thank you, Ian and Paula, and thank you, the listener, for sticking with us for that one. As you heard, there was a lot to get through.
Definitely. Yep. Yeah, a lot to get through there. It's very, very complex, as with all these kind of things. But it sounds like they're doing a lot to try and help, landlords and tenants try and find some way through the difficulties of COVID and rent arrears and all that kind of thing, which I suppose is a good thing.
Indeed.
If you want to find out more about anything relating to property disputes, make sure to visit our website at roydswiththeking.com. There's plenty of comment and more information about what we do. And if you want to listen to our podcast, make sure to subscribe. Where can people find our podcast, Liam?
People can find us on Apple Podcasts, Spotify, wherever they get their podcasts, including now YouTube.
Cool. Well, I guess all that's left to say is thank you for listening.
See you later.